Hello, this is Steve Rinka from the Rinka Law Firm, and I'm here today to talk to you about meal and rest periods under California law. Now, under California law, only hourly employees are entitled to rest periods and meal periods. Employees who are salaried do not get the same legal protections when it comes to meal and rest periods. Now, it is worth mentioning that under California law, most employees are assumed to be hourly employees, and it's the employer's obligation to show that someone who's classified as an exempt employee or salaried employee is properly classified as such. So it's only professionals such as lawyers, doctors, accountants, managers, supervisors, people with independent discretion, and there's a litany of other requirements under California law that someone must meet in order to be classified as a salaried employee. And that's something I'll discuss in a different video. Now, with respect to rest periods, if you work 4 to 6 hours, you're entitled to one 10-minute uninterrupted rest period. If you work 8 hours, you're entitled to two 10-minute uninterrupted rest periods. And both of these rest periods are to be paid. You do not need to clock out, and you can leave the employer's premises during this 10-minute period. Now, ideally, the first rest period should be taken in the morning or during the first half of your 8-hour shift, so probably around the 2-hour mark, and then your second 10-minute break should come around your 6-hour mark. Now, with respect to lunch breaks, if you work 6 to 8 hours, the employee is entitled to one 30-minute uninterrupted meal period. Now, the meal period can be paid at the employer's discretion. The employer is not obligated to pay the employee during this 30-minute uninterrupted meal period. Also, if the employer does not pay the employee for the meal period, the employee must clock out. And again, like the rest period, the employee is able to leave the premises during the 30-minute meal period and do whatever errands, go eat at whatever restaurant they want. Now, if an employee works 6 hours, they can agree to waive their meal period. If you work 8 hours, you cannot waive your meal period. You're obligated under California law to take your meal period. And if you work up to 12 hours, you're entitled to a second meal period for working 12 hours. Under California law, you can waive your first meal period, but you have to take your second meal period. And these meal waivers do not have to be in writing. And the employer is not obligated to pay you a 1-hour premium if you agree to waive your meal period. And that's also something important. Under California law, the employer is only obligated to give you the opportunity to take your meal period. If you elect not to take your meal period, even though you have the opportunity to, the employer tells you you can take your meal period, you have nothing to do, but you want to stay there working to get out early, well then that's your choice, and the employer is not obligated to pay you a premium. The California Supreme Court has made it very clear. The employer does not have to go around, babysit employees, and tell them, hey, you have to go take your lunch break now. The employer is only obligated to give the employee an opportunity to take a lunch. So if you don't take your lunch and the employer says you can, then that's on you. So that's something you must keep in mind. You can't turn around and go and not take lunch for a year and then say, well, hey, I wanted to get compensated for that 1 year of lunches I missed. And the employer will be like, you had the opportunity to and you didn't. So it's just, if you don't want to take your lunch period, that's fine. But be aware that if you decide not to, that falls on you and not the employer. If you have any further questions about meal or rest periods, please feel free to contact me, Steve Rinka, at the Rinka Law Firm. Our phone number 310-556-9653, and have a good day. Thank you.